of the Constitutional Bench is made in E015, my friends, so that effectively the subject matter of removal is being given only 5 minutes. I plead with you, give us 10 minutes.
How long do you need, Senior Counsel?
10 minutes.
You have 10 minutes.
Dr. Khaminwa, please, you are not audible.
Oh, I'm sorry, I'll speak now.
Yes, speak.
I received the instructions yesterday from Githu here that I come and make an application that Githu would like to be enjoying this month. We all know Githu here. We can't pretend that we don't know who this is. And we know that all Githu here has played in advancing jurisprudence, constitutionality, and the rule of law in this country. So I urge you respectfully that you place my name on record. Secondly, I would like also to place my name on record in my own right as an elder, as a bar, and one who has seen for a number of things which I may not be able to say if I'm saying the truth.
That is okay. We have done that.
Thank you very much. May I then comment on one small thing?
Yes, sir.
My lords, the country is in a crisis. There's a constitutional crisis. There is a national crisis. And our coming to this court is like commencing or opening an opportunity for healing in the country. And if I may say so with tremendous respect, this is not a matter where it should be allocated some 5 minutes, 10 minutes, 20 minutes. No, that is not suitable. Let these lawyers talk. They are part of the healing process to the 15 million of Kenyans. A number of them are glued now to radios and TVs, trying to hear what is being said in this court. And for this honorable court to come and say that my ever friend, Mr. Muigai, will only have 10 minutes, will have no 5 minutes.
Mr. Muigai asked for 10 minutes and we allowed him to have 10 minutes.
He said so because he was under coercion.
What? Okay. I think, Dr. Khaminwa.
I have taken the trouble to read this Constitution of Kenya. I have taken the trouble to read the Constitution of other countries. In fact, the way things stand at the moment, the Constitution law is evolving in such a manner that it's no longer confined only to Kenya. We can have a concept of international constitutional law. And if you read that law, including the American law, which I've taken the trouble to read, and which I've had access to it for many years.
Dr. Khaminwa, we made proposals and we gave directions. Apparently, you are not satisfied. What is your version? What would you want us? You want to give everybody how much time?
My Lord, forget about the concept of time. Forget, where are we heading for? What are we heading for?
So, yeah.
Yeah, we want the country to wake up and to revive and to give the life to the country. The country is Kenya, if you don't know what I'm talking about. Your Honor, let the lawyers say what they want to say. This should be part of the healing process of the whole country.
Dr. Khaminwa, I ask you,
yes.
We have given directions on time allocation.
Your hands are not tied with respect.
Okay, tell us, just tell us, in your view, how much time do you want us to allocate parties?
What I'm saying to the we talk about time in the civil matters and so on. But we are dealing here with the issue of impeachment. Issue of impeachment of the deputy president. It's not a small matter at all. It's a matter that is starting the whole nation. It has paralyzed the nation.
We have heard you, Dr. Khaminwa. What we'll do...
Let be given as much time as he wants.
Let
the professor be given as much time as he wants. Let the Honorable Attorney General be given as much time as he wants. That is a healing process. And from this court, we shall all march forward with confidence. If I may quote Muigai Makinyata, kifua mbele na matako nyuma.
Okay.
Let us talk about crime. Where are we going?
My Lord,
Where are we going with?
maybe I can assist Dr. Khaminwa.
With respect, will you sit down? Khaminwa is talking. Will you sit down?
Dr. Khaminwa,
Under the rules of this court,
Yeah.
senior counsel has preference, speaks first before any other person except the Attorney General. So if you would please sit down, I as senior
I will
counsel.
not sit down. When I practice law, you are still doing breastfeeding.
That is also true. So my Lord, I want to suggest.
Don't give yourself
My Lord, I want to suggest.
excuse me. Dr. Khaminwa, finish what we are saying.
What
So
I'm
that
saying to you, my Lord, we need a healing process, and this court is going to provide that healing process. Let the lawyers say what they want to say. What are we hurrying for? Let us not have some people calling themselves professor or senior counsel, titles that don't mean anything at all when they come to this.
I think they mean something, Dr. Khaminwa. They do mean something. Those
something means something when it's you and you approve it. Yeah. My Lord, all that I'm saying to you, let people talk. Let people address you.
Okay,
Where are we going?
people will talk,
When
but
the country is burning.
Dr. Khaminwa, you have made your point, please.
Yes, thank you very much.
You have made your point.
I have made a point.
Yes. Professor
We have
Githu.
a deputy chief justice who has been removed irregularly. Let us be given time to be able to address it.
My Lord, I think those of us who are representing substantive respondents, we all agreed that you have given orders that we will comply with, including my learned senior P.K. Muigai, who I believe you have added some more time and he's happy with that. Maybe it would help if we informed Dr. Khaminwa that it is not the whole matter that is being heard in 10 minutes. It's a very small slice of an application on empanel. That's all I wanted to clarify.
So, Dr. Khaminwa, I've heard what you said. We'll stick to the time allocations, but in the event that one party needs more time, they will tell us.
When we come to substantive matters, let people...
I agree with you.
Yes.
I agree with you.
Yeah.
Thank you.
Where are we heading to?
Thank you.
Yes.
Madam, in view of that time allocation, and I thank senior counsel, the senior most going by the Kenya law reports before you, may I beseech your lordship, Dr. Khaminwa.
Thank you.
My Lord, even the report of the East Africa law confirms that. My Lord, the point I need to make, and I beseech you,
Justice. That justice will not be possible.
This application, questioning how the panel was put together, should be heard together. For the very simple reason that they rely on the same set of arguments and facts. And I draw your attention to paragraph 5. They say that the impartiality of this court, the one we are before, has to be questioned. And at the end of their prayers, they say that it is therefore in the interest of justice that this honorable court accuse itself. It would be gravely injurious to the respondents if they were allowed to prosecute this application, take one bite at attacking the court, then however the court rules, bring the other application for recusal and take a second bite. We would like to argue both of them together. Secondly, we would like an allocation of time, because it is quite clear to us that in the absence of directions allocating time, we are going to have another long afternoon of long-winded speeches that do not address the specific issues. We are willing to say in advance that whatever time you give us, if you give 10 minutes each, we shall accept. If you give 15 minutes each, we will accept.
Professor Githu, which applications are defined? How many applications?
The one you directed, my Lord, in the morning. Yes. But it is in that application that has been filed by Khaminwa and company advocates. That is the application that seeks, on the one hand, that questions how this bench was appointed, and on the second hand, requires the recusal of this bench.
So for avoidance of doubt, it is one application.
It is one application.
There are 3 applications.
But there is an earlier application for recusal. Correct. And that's why I'm saying we probably can hear both of them together.
Yes.
I'm sorry, my lord, but my lordships and my lady, I just wanted to remind the court of Article 159 of the Constitution. In exercising judicial authority, the courts and tribunals shall be guided by the following principles. And 159(2)(b), justice shall not be delayed. So I'm requesting your lordships and my lady to kindly refer to that provisions and let us move forward. Thank you.
My lord, let it come on record that this is the first time in which, on a matter of extreme national importance, we've been given 1 hour to be able to do an application, serve it, and come back to court. We have tried to do the best that we could in terms of complying with those directions. Of course, one of the issues that we could not be able to do is that the written application could not be able to do full justice to the instructions that we've been given and to our case. And therefore, my lord, when Professor Githu Muigai stands senior counsel to say that we need to be gagged on the issue of time, we protest. We shall require sufficient time. This sufficient time is not forever. This sufficient time, at least for purposes of the 3 presenting the that applications, is 1 hour. It is the least that people deserve in an application of this nature. Secondary issue, my lord, is the issues of consolidations. Those issues of consolidation are as different as UDA can be from Jubilee. And the issue is, for purposes of the difference, the application under Article 165, and we did not hear you talk about the inclusions, because we've had to include. There are earlier